Sorry, Mr. President.
How are you,
Good afternoon.
Are you well?
I'm good today.
Good to see you.
Yeah, good to see you.
And this winter, you're still on your feet?
I'm on my feet. I'm on a cripple. I'm a croco.
Oh no, you are not a croco.
Good afternoon.
How are you?
I'm good.
Very well.
Elizabeth Palomir.
You speak all those languages that surround your surname?
Yes, Changani Nasutu.
Nasutu. Fana me.
Good afternoon.
How are you?
Fine, thanks.
Very well.
We have 2 volumes
Yes.
of this report.
Yes. Why? I mean, the judiciary is really going up. Look at the presentation. Can you see how beautiful this is?
Please join the picture.
It made a secret of women.
Without any doubt. That I never doubted.
Retired Constitutional Court Justice Bates Elizabeth Nkabinde has yesterday, Wednesday, July 1st, 2026, presented to President Cyril Ramaphosa the report of the inquiry into the fitness to hold office of South Gauteng Director of Public Prosecutions, Advocate Andrew Chalk. President Ramaphosa established the inquiry on September 29th, 2025 in terms of Section 12, subsection 6A of the National Prosecuting Authority Act 32 of 1998. The mandate of the inquiry was to investigate and determine whether Advocate Chalk was fit and proper to continue to hold such office in the context of certain serious allegations regarding his fitness and propriety to hold such office. Its terms of reference were in line with the requirements of the National Prosecuting Authority Act, read with Section 179, subsection 3 of the Constitution. President Ramaphosa placed Advocate Chalk on suspension with effect from July 20th, 2025, pending finalization of the inquiry. Today, President Ramaphosa expresses appreciation to Inquiry Chairperson Justice Nkabinde, assisted by Advocate Elizabeth Batohi, Senior Counsel, and Attorney Machego Ramagaga, for the work undertaken by the panel. President Ramaphosa will now study the report and subsequently make a determination. It is so sad that the person who complained to the president about Advocate Chalk was former NDPP Advocate Shamila Batohi, who didn't finish her testimony under cross-examination. She walked away from the commission. I'll attach the video to remind you what happened.
I can give you an example to make it easy. Major General Boysen is charged with 7 counts, 2 of racketeering, 2 of murder, 1 of defeating the ends of justice, and 2 of violating the provisions of the Firearms Control Act. My question is a simple one. Does that charge exclude the 2 murder charges, the 1 charge of defeating the ends of justice, and the 2 charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batohi, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Boysen.
It does not exclude it in the context of racketeering.
Advocate Batohi, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. But I'm asking you is that Major General Boysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer. is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. If you withdrew racketeering, Major General Boysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
So
now-
when I did withdraw the
No,
racketeering,
I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Boysen should not have faced the murder charge?
not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Boysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Boysen.
Yes. Those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Boysen with murder?
My understanding is that Major General Boysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Batohi. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the
Yes,
question,
no,
because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision
Yes.
in relation to the Katomena matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Katomena matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now,
Yes.
that he did
Yes.
make this particular
Yes.
prosecutorial decision
Yes.
as regards the charge of murder against Major General Boysen.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge. Let's come back then, Advocate Batohi, to understand what 3.1.1 is about. You have said that your understanding is that murder featured only because it was a predicate offense, not because it was an independent offense. Is that correct?
It was a predicate offense to racketeering, that's correct.
Yes. And therefore, it is irrelevant to Section 2, subsection 4 as an independent offense. It is only relevant as a predicate offense.
That is correct.
Yes. All right. Now, the reason I'm asking you this is because even on your own version, you've accepted that at least in relation to one of the charges, there was sufficient evidence to prosecute. Is that correct?
No, I'm not understanding you.
Well, you've told us that you gave all of the dockets to the DPP of KZN. She enrolled one case against Mr. Padiache on a count of murder. So she must have considered that there was sufficient evidence to charge Mr. Padiache with murder.
Yes, I didn't realize you were referring to that docket. That's correct.
Yes. That's why I come back to say in at least one of the cases, there was sufficient evidence to proceed with a murder charge.
That's correct.
Yes. Now, that distinction is not made clear at all in 3.1.1. If you read 3.1.1, it suggests that in none of those cases, there should have been a charge.
Against Major General Boyson. That's what that suggests.
No, that is false. It says Major General Boyson and members of the Cato Manor unit.
Let me read this carefully.
Mr. Padayache was a member of the Cato Manor unit.
The point I made earlier is that this related to racketeering charges. And therefore, it's clear here that this section is relating to racketeering charges and murder as a predicate offense and not as separate independent charges. And so it's correct in that regard that it is racketeering. It doesn't refer to murder at all.
Yes, I thought we had moved from that question and we were debating the independent charges. And I asked you a question, whether you would accept that in at least one of the dockets, the case against Mr. Padiache, there was sufficient evidence to charge. And I understood your answer to be yes.
That was my answer.
Yes. And when I proceeded with that, you said, well, exclude Major General Boyson. And then I pointed to you that actually exclude all members of the Cato Manor unit.
The point I make is that whether it's Major General Boyson or all members, this particular paragraph refers to racketeering charges and not independent murder charges.
Yes. Now, could I then ask you to turn over the page? 3.1.1.1 refers to supporting a decision to prosecute the accused. Who is the accused?
All the accused in the racketeering charges.
Yes, that's where we come back from, where you say no evidence justifying the decision. And now we understand that you would accept in relation to one, that there was evidence justifying a murder charge against Mr. Padiache.
But not a racketeering charge.
Yes, I
against
understand.
anyone.
You've made that clear. I'm asking you a different question. Was there sufficient evidence, in your opinion, having studied the dockets, if you did, to support a murder charge against Major General Boyson?
There wasn't.
There wasn't. Now, you gave evidence earlier that you did not study the dockets and you relied on a memorandum by Advocate de Kock. Was that evidence accurate?
That's correct. But my answer now also relies on the evidence of a report of the DPP KZN.
Yes. I'm not asking you about the DPP KZN. I'm asking you at the time you took the decision to institute a disciplinary case against Advocate Chauke, you relied on the report of Advocate de Kock. You never studied the docket. Is that not correct?
That's correct. I didn't, let me just check the time that I decided. No, that's correct. I didn't study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boysen. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boysen without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis. So it's certainly not irresponsible. It is what is expected of a responsible national director.
Yes. But can I also suggest something else to you? That Section 2 of the Prevention of Organized Crime Act is within the exclusive power of the NDPP. Do you accept that?
I'm not sure what you mean by exclusive power, but
Well,
certainly
only the NDPP can sign a racketeering certificate under Section 2, subsection 4. I would have thought that to be obvious.
certainly I agree that only the national director can sign that authorization.
And exclusively the NDPP. No one else can sign a racketeering certificate.
That's correct.
Yes. It's in that context that I say, for you to tell the panel that there is no case against Major General Boysen, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing.
I repeat what I said.
Of course.
There's case law that states that a national director is not expected to read every docket and to look at every piece of evidence before coming to that conclusion. A national director, it's permissible for a national director to consider evidence that is presented to him or her by a team, presentations, and to ask for specific aspects of evidence if he or she requires it. But it's certainly not expected of a national director to read every single docket in any context. Sometimes a docket can fill a room, and it's certainly not expected that that is what a national director should do.
Well, can I challenge you on that and put two propositions to you? Firstly, the docket against Major General Boysen does not fill a room. It's a small docket. Do you accept that?
I'm not sure that there is a docket against Major General Boysen. I know that there were 23 murder and other related charges, dockets. I'm not sure that there ever was a racketeering docket as such.
Now, you see, the problem is that you answer, but you always overlook what you wrote. Go to 3.1.1.1, where you say, supported a decision to prosecute. I mean, I know you say it's the president who says this, but you never wrote this, or you don't know the difference. So I will accept that until I see what you wrote. Your answer remains qualified. That there was no evidence justifying the decision, and that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. You are the one who relied on case dockets. Now you are telling the panel there was no docket.
I said there was dockets, there were dockets, lots of dockets, but I'm not aware of a racketeering docket as such.
No, Advocate Batohi, I think there is a real problem. You have said that 3.1.1 is exclusively about racketeering and does not include the independent offenses. And you have also confirmed in 3.1.1.1 that that too is exclusively about racketeering. The charge refers to case dockets. What case dockets are those?
Which charge refers to case dockets?
Read 3.1.1.1.
Yes, it does appear there.
It was put there by you.
I'm not sure about that. We'll have to check that.
Yes. But then answer my question, please. The docket that is referenced, we have gone through this exercise ourselves. It is only 7 charges against Major General Boyce. It is not the exaggerated docket that fills a room. What do you say to that?
The only point I made about dockets that fill a room is to make the point that it is not expected of a national director to read every bit of evidence when a decision is made. That's the only reason why I mentioned that. But getting back to this issue, there were dockets relating to, there were the 23 case dockets. I'm not aware. Let me read this carefully before I answer this. This is clearly incorrect, because to say that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. It's not our case that Advocate Chauke asked the DPP to sign any case dockets. So this is clearly incorrect. And
so the charge is incorrect.
If I may be allowed to complete.
Yeah, all right, sorry, I thought you had finished. Please continue.
It's okay. And or the prosecution memo. He sought to improperly have the acting sign the case dockets and or sign the prosecuting memo. If you read it like that, it's incorrect. That is not what we're saying.
So charge 3.1.1.1 is a wrong charge.
It's incorrect.
Well, incorrect and being wrong are the same thing.
Well, part of it is correct, is that Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no decision, justifying no evidence justifying the decision. And then the next part of it is incorrect to the extent that I've indicated.
You see, that's why I need the memorandum you gave the president to see whether the president is at fault for charging Mr. Chauke incorrectly, or whether you are at fault but are now escaping responsibility.
I'm trying to explain as best I can and not to escape responsibility.
Yes, no, I understand that. I'm not criticizing you, I'm criticizing your evidence.
It's fine.
Now,
Before you proceed, I think this will also help us, Advocate Batohi. When you look at the gazetted terms of reference, the date is the 30th of September, 2025.
I don't have that gazetted copy in front of me.
The front page
Oh,
of
there you
the
go.
Gazette.
I have it now. Yes, that's
Regulation
correct.
Gazette number 11889, volume 723, 30 September 2025, number 53444. You
That's
have
correct.
that. When did you see for the first time the gazetted terms of reference?
I'm not sure, Chairperson. I can't recall when I saw it for the first time.
Should I assume that by 1 October 2025, you had already looked at the terms of reference?
No, we can't assume that, Chairperson.
Should I assume that by the 17th of October, when this inquiry started, I beg your pardon, by 17th of November, when this inquiry started, you had already looked at the gazetted terms of reference?
Chairperson, I honestly can't remember when I looked at it and whether I scrutinized it at any great detail or cast a quick look through it. I honestly cannot recall that.
When you took oath, the first day you took oath, had you already looked at the terms of reference?
Chairperson, on the first day of the inquiry,
On the first day you took oath,
I would certainly have had a look at it, but I don't know to what detail.
you may proceed, sir.
Just one thing. Advocate Batohi, when the bundles or documentation was prepared for this inquiry, it was prepared with a view to addressing issues raised in the terms of reference. Is that correct?
I'm not aware that it was prepared for that specific purpose.
Did you care to establish as to whether the documentation was prepared for that purpose?
No, I didn't.
Sorry, a follow-up. Advocate Batohi, when you prepared your affidavit together with your legal team, you knew that you were preparing an affidavit to come and testify in relation to the terms of reference in this inquiry?
I knew that I was preparing an affidavit in order to come and testify before this hearing.
Testify in this inquiry in terms of the terms of reference, wherein you referred a matter to the president, who then constituted an inquiry and issued the terms of reference to deal with whatever you referred to the president.
Yes, the terms of reference were for the panel, and of course, evidence was going to be provided to support what's in the terms of reference by various witnesses.
Advocate Batohi, when you prepared your affidavit, you prepared your affidavit to sustain the allegations that you made to the president, which, well, I'm not sure whether rightly or wrongly, convinced the president to constitute a panel. But the president depended on the evidence or on the information that was supplied by you, which you intended to support by way of an affidavit that served before this panel. Is that correct?
I didn't prepare the affidavit with an intention to support the terms of reference. I prepared an affidavit on the basis of what I knew and what I did in this matter. It's not like I prepared the affidavit and then checked whether it's aligned with the terms of reference. That's not what I did.
And what you knew is what you submitted to the president for the president to take a decision to set up an inquiry.
That's correct.
Thank you.
Thank you, Madam Chair. Advocate Batohi, I'm not yet done with this inquiry about case dockets. You have now testified that the reference to case dockets and trying to get someone else improperly to sign is incorrect. Okay, I'm not going to quibble with that. But do you accept that the case against Major General Boysen, whether contained in a docket or elsewhere, is a fairly narrow case? It is not the example that you posed of a docket filling up a room.
It's certainly not a docket that fills up the room. That's correct.
Yes. Now, it also continues to say, and or prosecution memorandum. That's one of the things I don't understand. You never gave evidence in this inquiry that Advocate Chauke sought to have Mr. Molotra sign a prosecution memorandum. Is that also incorrect?
I mentioned earlier that is incorrect.
Yes. So both that case docket reference and the prosecution memorandum are wrong.
It is not our case that Advocate Chauke sought either of those to be signed by Advocate Molotra.
Yes. Now, then it continues to talk about evidence implicating the accused. Who is that accused?
I would imagine it's all the accused.
All of those accused with what? Because there are people like Mr. Mostert, 11 counts of murder. Does it include them or not?
For racketeering charges.
So all of the accused on racketeering.
That's correct.
Yes. Now, the way then it would read is that the case docket would be a case docket for racketeering. The prosecution memorandum would be a prosecution memorandum for racketeering. But because the charge is wrong, we can strike that out. We can put a red pen across that.
Can you repeat that?
I'm saying the way it would read, before your evidence today, the way it would read would be, it's the case docket for racketeering. And then it's the prosecution memorandum for racketeering. But because you have now considered that that is a wrong charge,
I have a case docket for racketeering. I'm aware of a lot of other dockets, the 23 murder dockets and related charges. I don't even know if there was a case docket for racketeering. So I don't understand your question.
Well, my question is exactly linked to what you have just said, that you've charged someone for trying to get a signature on a case docket that you say doesn't exist. You've also charged someone for trying to get a prosecution memorandum to be signed, which you admit was never done.
I have not charged anyone for that.
All right.
I did indicate that that is definitely not the case, and that is definitely an error on that, because there's no evidence at all that Advocate Chauke was required to do any of these, either sign a case docket or sign a prosecution memo.
Yes.
The evidence is that he sought Advocate Molotra to sign the indictments.
Indeed, there is not a single charge here that refers to an attempt to sign an indictment. If
That's
you can
correct.
see it, show me.
That's correct, there isn't.
Yes.
And it's not meant to be, because
Yes.
there's no evidence to that effect.
No, I thought you said the case against Advocate Chauke is that he sought to have Advocate Mlotshwa sign an indictment.
That's correct.
I am saying to you, there is not a single charge here that refers to Advocate Chauke attempting to get Advocate Mlotshwa to sign an indictment.
That's correct. I'm not aware of the other, if it's anywhere else on this, but
But
certainly
you
not
can go
in this.
through them now, there is enough time. And then show me where it is alleged that Advocate Chauke sought to have Advocate Mlotshwa sign an indictment.
Well, it may or may not be there, but that is our case.
Well, Advocate Batohi, please.
Just before you proceed, just one thing. Advocate Batohi, did you familiarize yourself with the terms of reference?
No, I didn't.
And you are the complainant in this matter?
That's correct.
Thank you.
Well, you can call me the complainant. It's the president that decided. So I'm not sure that I'm the complainant, but I certainly made a referral to the president.
Which question are you answering now?
Whether well, it wasn't a question, it was a comment that I am the complainant in this matter. And I'm seeking to clarify that I don't see myself as a complainant. It's
Thank
the
you.
president who decided. I made a referral to the president.
Thank you.
All right, I'm gonna come back to this question by Madam Panel Member Ramakhaga, but I still want an answer to my question, which is, show me where it is alleged that Advocate Chauke sought to have Advocate Mlotshwa sign an indictment.
I accept from you that it isn't, otherwise it's going to take me a while to read this entire terms of reference.
No, it won't take you a while. There are only 5 paragraphs. So you can do that now and tell us which paragraph refers to Advocate Chauke trying to get Advocate Mlotshwa sign an indictment.
May